Hello everyone, got a Second Amendment update for you today. Earlier this year, the Fifth Circuit Court of Appeals heard Reese versus ATF and held the Second Amendment does cover the right of 18 to 20-year-olds to purchase firearms because the Second Amendment protections extend to all law-abiding adult citizens. Now, what does law-abiding mean in this context exactly? Well, that's a topic for another video. But anyways, this was a big win for the Second Amendment. The case was then remanded back to the district court for the court to enter a judgment holding the young adult handgun ban unconstitutional. This is a typical part of the appeals process. Basically, when a higher court decides something, they often remand it back to that originating court to then enter its own judgment consistent with that higher court's ruling. But last week, the district court in Louisiana ruled the Second Amendment Foundation must turn over its members list as part of the court's judgment in Reese versus ATF. The Second Amendment Foundation was not going to let this stand. In a press release filed on October 10th, Executive Director Adam Kraut stated, "The Second Amendment Foundation has never and will never provide the government a list of our members, and we won't be strong-armed into turning over the private data of those who support Second Amendment Foundation and the Second Amendment." Also on October 10th, the Second Amendment Foundation filed a motion to amend the judgment of the case. This motion was joined by the Department of Justice, so the government joined in on this one as well. The motion states, "The government, as a general policy, does not compel disclosure of the identity of members of private organizations, and the government did not seek to do so here." The parties further argue the disclosure order violates the First Amendment. And I tend to agree that this would violate the First Amendment. Maybe you could argue it's compelled speech here. The parties provided an amended order for the judge to sign off on. This is actually fairly common practice for lawyers to draft proposed orders in cases, because when you do this, you make it that much easier for the judge to take your side. They have less work to do. All they have to do is sign off on your order. So the parties requested a ruling by October 14th, just in a few days. So I hopefully will have an update for you later this week. The district court judgment filed October 7th has some other problems actually limiting relief to the plaintiffs. We'll dive into this in a future video as well. So share what you think about the court's judgment and the foundation's quick actions in the comments. Now let's see what happens next.